thank you all for coming. It's a really full house. I want everybody to keep it down. Keep quiet, because we have a very exciting panel that it seems like everybody here is very interested in hearing about, which is about the U.S. Patent and Trademark Office's war against unauthorized practice of patent and trademark law. By way of background, every year, thousands of foreign non-U.S. corporations and individuals file patent and trademark applications in the United States. When they do, these foreign entities typically hire local counsel and local agents in their home country in which to deal with the issues for obtaining their patent or trademark applications, rather than contacting the U.S. attorney directly. These individuals who are not licensed U.S. attorneys, we refer to in the trade as foreign associates. A foreign associate plays a very important role in the delivery of patent and trademark legal services for foreign clients. The foreign associate will not only serve to be a translator and help the U.S. counsel understand other information that they've learned from foreign clients in the foreign language, but they can serve as an advisor for their foreign clients, as well as a drafter of documents for filing in the Patent and Trademark Office, including patent applications, trademark applications, and responses to official actions. So they play a very big role in the process. Over the past few years, though, we've noticed an uptick in a significant amount of fraud occurring in foreign-originated U.S. patent and trademark filings. It's gotten to be such a bad point that the USPTO has stepped up its enforcement actions against both the attorneys that have been involved in these representations, as well as the foreign associates that have been involved. The PTO is scrutinizing their work and has issued sanctions orders against patent and trademark attorneys, as well as their clients, for misconduct before the office. Those sanctions orders are very significant, and they've resulted in thousands of patents and thousands of trademark applications being summarily canceled by the U.S. Patent and Trademark Office. So to discuss these issues, we've assembled an expert panel who came long and far to present to this wide audience. I'd like to introduce you to my immediate, to your left, my immediate right, is Kyle Choi. Kyle is a senior foreign attorney at the Shin & Kim firm, where he heads the Shin & Kim's intellectual property litigation practice group. Kyle primarily concentrates on international litigation with specialty in intellectual property law. Kyle advises and represents U.S. and Korean companies of all sizes with respect to IP disputes before the U.S. district courts, in the U.S. International Trade Commissions, and at the PTO. Kyle is also a registered U.S. patent attorney. Next is Tom Kowalski. Tom is a registered U.S. patent attorney and partner in the law firm of Duane Morris in their New York City office. Tom is chair of the Life Sciences, Pharmaceuticals, and Biotechnology division of his firm's intellectual property practice group, and he is a member of the firm's Life Sciences practice group. Tom's practice includes biotech, chemical, and other types of patent subject matter in prosecution, licensing, investor due diligence, and counseling and in litigation, with extensive experiences in the area of life sciences, personalized medicine, biotechnology, and chemistry. Tom has appeared before courts and in IP-related proceedings throughout the world. And finally, I welcome Bill Park. Bill is the managing partner of William Park & Associates Limited in Chicago, Illinois. Bill is a registered patent attorney and concentrates his practice in the field of U.S. patent prosecution before the USPTO. He has represented many high-tech corporations over 23 years in all phases of patent procurement and enforcement, including patentability assessments and procurement of many key patents for his high-tech corporate clients. Today, our group is going to discuss what constitutes the unauthorized and authorized practice of patent and trademark law before the USPTO. We're going to explain how the USPTO's rules of professional conduct apply when practitioners who provide legal services to foreign clients, and we'll consider some best practices for ethically representing IP clients who work through foreign intermediaries. I'll turn it over to Kyle.
Turns out that we don't have clickers, so we have to come up here and manually. Let's see. All right, so before we can talk about what is improper, we need to know what is proper. So under United States Patent and Trademark Office rules, the people who can represent clients at the PTO must be a licensed U.S. practitioner. They're the only ones that are allowed to practice before the USPTO for both patent and trademark matters. For trademark practice, you just have to be you have to be any U.S. licensed attorney can practice before the trademark part of the office. For the patent practice, and if you want to represent your clients for patent registration, as well as other patent procedures before the patent office, you have to be a registered patent attorney or as a patent agent. That requires not just, let me explain that a little bit. So the language of what a patent attorney is slightly different between, let's say, in Korea and in the US. In Korea, a lot of patent attorneys are considered to be what in the US would be equivalent to a patent agent. Patent agents are basically somebody who's passed the patent bar and are allowed to represent clients before the patent office, but they don't have a at-law bar so that they can't go to court. In the US, in order to be called a patent attorney, you have to have both. So you have to be a US licensed attorney, as well as somebody who has passed the patent bar. I think that at last count, approximately there's 1.3 million practicing attorneys, and about 50,000 active registered patent attorneys, patent practitioners, both including patent attorneys and patent agents, who are practicing before the patent office. So what does it mean to be practicing before the patent office? Basically, I'm not going to read the statute to you, but basically anything that you submit to the patent office, any communications you do with the patent office, any hearings or interviews you have with members of the patent and trademark examiners, and any advising that you do to the clients in order to do all those other work is considered to be practicing, or practice before the PTO. To break that down a little bit, for patents, we're talking about preparation of the application, drafting of the application, writing the specifications and what we call the claims, any type of responses that you submit to the patent office. If you get what's called an office action, when a patent examiner has examined your application and have provided feedback to you. Any type of activities before the PTAB. PTAB stands for Patent and Trademark Appeals Board, where appeals of certain types of rejections, as well as invalidation proceedings proceed. As well as, again, any type of advising that you do to clients to do these things. Trademark side, almost the same. If you're preparing patent trademark applications, advising the client on how you're going to be able to or not be able to get a trademark registered with the trademark office. The trademark side also has its own trial and appeals board called TTAB, the Trademark Trial and Appeal Board, as well as all the communications that you'll be filing to the trademark examiner for your registration. So if you're not a registered licensed attorney for trademark issues, or if you're not a registered practitioner for patent issues, everything we just said prior to this, you will be considered doing unauthorized practice of law before the patent office. There is a rule that allows for the patent office to hire what they call non-practitioner assistants to assist you as the licensed practitioner to prepare and do whatever you need to do. But it has to be specifically supervised by a person who is the licensed practitioner. And we'll get to that later by my other colleagues. The problem or the consequence of doing what we call UPL, or unauthorized practice of law, before the patent office, Mike alluded to it earlier, is that you can either get disciplined as a practitioner who does something wrong, or you can be sanctioned. And the sanction, the difference between the two is that the discipline will mainly only affect a practitioner. But sanctions will affect not just the practitioner, but also the client who is trying to either get the patent or the trademark. And in many cases, in many states, if not all, UPL is actually a crime. And so while the USPTO doesn't consider it a crime under state law, you can be fined or even committed to imprisonment for unauthorized practice of law. I'm going to hand this over to my colleague Tom to go through the rest.
Thank you very much, Kyle, and obviously thank you to Mike and to the ABA for having me speak with you today. And so I'm going to start with a little history of mine, all right, because again, it's all about me. But more importantly, we're talking about, I was a law clerk in 1985, a patent agent, as Kyle explained, in 1986, and a patent attorney from 1987 forward. So as a youngster, I was exposed to a foreign associate, as well as also in-house individuals. I had the pleasure of working at a firm that represented BP, but also another partner had work incoming from foreign associates in Asia, another partner from Italy. So I was exposed to what is this concept of a foreign associate. And notice the definition here, all right? The definition is that it is someone who represents interests of non-U.S. client and assists the client in dealing with the PTO. Why I highlight that? Because the point is, it's not the client. The foreign associate is not the client. Okay, so, I need a little help here on what I hit to advance. Right. Okay. All right. So here's why I went through my personal history. Because here I am a law clerk in 85, and the PTO adopts this code of conduct, if you will. And practitioners are somewhat in an uproar. I'm a youngster. I have no idea what they're really upset about. Now, over all this time, I do understand. And that's because then and now, there are some practitioners who act as a mere conduit for the foreign associate. I have experienced individuals who would literally either receive pre-written papers that they would just sign and file, or instruction letters that their practice was handed to a secretary. The secretary would type it into the form of a paper to go to the USPTO, and they would sign it. And that was just a mere conduit effect. I also had the experience of attending INTA, the International Trademark Association annual conference. And I heard and been standing around a group of people having coffee and one person saying to the other, I can send you 30 cases next year if you send me back 30 cases. And so it wasn't a representation of a client, it was a case trading arrangement. And so you can see the practitioners didn't like the idea that they shall not be paid by the client, or the non-client rather, because receiving those other 30 cases back was actually a type of payment. And being able to just sort of be a conduit means you didn't have to do any independent judgment. And if you were required to do independent judgment, heaven forbid you have to do work. So then in 1987, the USPTO gives a little bit more guidance, all right? And that we can rely upon the advice of a corporate liaison, so the in-house people say at BP, as well as the foreign agent, foreign attorney, if you will, patent agent. However, you really need to know that the practitioner rather has to know that there's consent from the client that the agent is acting on behalf of the client. But this is not something easy to do. Yes, certainly the people who are being employed at BP, I knew they were authorized, they're employees. On the other hand, the foreign associates, they weren't going to give away their arrangement with their clients. And so you had sort of a gray area. We assume you're authorized by the client, but are you really? And so here, continuing with this same point, is the fact that what do you do? How do you make sure you're aware of all of what's going on? Well, now, in terms of the practice having developed, what we do is we use a retainer letter. Back then, all right, I had a situation. All right, Company X in Europe retained me personally for prosecution. They had their cases with a number of different foreign firms to the US or patent agents throughout Europe. Patent application comes into the firm I was working with at the time, and one of the partners, that's my case. That law firm is my client. I had to pull out the guidance as well as the letter from the client that actually hired me to illustrate that in this instance, the client applicant is the client, not the law firm. And the idea here is that you work this into the retainer letter so that it's clear that you're going to know who is authorized and not. And so this 1988 guidance that came afterwards clarified very clearly that the US lawyer's client is not the foreign associate, but it is the actual applicant or assignee. And so what did the USPTO do is even better, is they suggested when you do a power of attorney, you get it that the client is indeed authorizing the attorney to act. And so here we have what was at least some degree of clarity, even though quite frankly, to this day, I will tell you, I think practitioners have an issue as to understanding who is or who is not the client. With that, I believe this goes now to you, Bill.
Thank you, Tom. This is this button right here.
Yeah, exactly.
So, recently there has been an explosive growth in trademark patent application filings from foreign countries, particularly from China. Many of which appear not to be legitimate trademarks in the United States. As a result, the United States Patent and Trademark Office in 2019 changed the rules. As for trademark applications, the USPTO imposed a requirement that all foreign domiciled applicants must be represented by a licensed US attorney. The reason the USPTO made this rule change was he thought that the having a licensed attorney, a licensed U.S. attorney, would better protect the USPTO from fraudulent applications filed from the foreign domicile applicants, because the licensed U.S. attorney could be punished, whereas the USPTO has no real ability to punish a non-U.S. attorneys. There are many problems seen with trademark practices as such. Yeah. Okay. So previous screen, you saw the explosive growth in filings from China. The problems that the USPTO has seen in recent years in trademark application filings is, for example, the false use in commerce claims, fake specimens, improper description of goods or services, false date of first use, unknown identity of a true applicant, identity theft of applicants or representatives, and a false or improper signatures on trademark filings. Okay. The U.S. patent attorney, the USPTO has published, they have done some studies, and in 2021, they published a study called Trademarks and Patents in China, the Impact of Filing Trends on the USPTO. The filings could be driven by the market factors, which is really fair and reasonable, but there are some non-market factors that motivates this explosive growth in filings in the United States with the USPTO. The legitimate market factors include organic growth in manufacturing. If you do more of manufacturing activities, it'll motivate you to file more patent applications to protect your rights. There's the importance of Amazon brand registry, and there's a pandemic, which sort of did a lot of cutback in those IP activities. However, the problems arise in non-market factor-driven patent or trademark filings. For example, the Chinese government provides subsidies. Sometimes they even set the quotas to file those applications, which would exceed the cost of the United States the filing fees. As I mentioned, for example, China has mandated to increase the patents and trademark application filings, and sometimes they just file application the marks, the ransom marks to legitimate owners, and they would thwart the Amazon takedown notices. The USPTO is seeing the increase in patent apps from the non-U.S. clients, especially the China design applications. Some of those problems are the false microidentity certifications, the incentivizes applicants to get patents solely for the subsidy. It also motivates the strategic filing behavior, such as application splitting to get the more number of application filings. It's simply done to get greater number of patents. And lastly, the false or improper signatures on patent filings. And then I'll hand over to Mike.
So it's important to note here that when we're talking about the foreign associates and other non-lawyers who might be engaged in unauthorized practice of law, that the USPTO is very limited in its powers. It has no authority to file a lawsuit against someone who is not a practitioner. It can't, it has no authority to do anything independently against someone who is not either a licensed U.S. attorney or a licensed U.S. Patent agent. The USPTO only has the ability to refer a matter of unauthorized practice of law to what's called appropriate federal, state, or local authorities or law enforcement for investigation. For example, in a case a few years ago involving a patent marketing company that was engaged in wide-scale fraud and unauthorized practice of law, the Federal Trade Commission actually was referred a case from the USPTO, and the Federal Trade Commission was able to then get a district court, after filing a lawsuit in the federal district court, was able to get an injunction to shut down the invention promotion company. The USPTO itself can't do that. And while state or federal authorities can file actions in court to stop these types of conduct, there is very little motivation or practical ability for them to do so when the person engaged in these wrongful behaviors is not located in the United States. So where you have a case of unauthorized practice of law coming out of China, for example, and there is no practical enforcement measurement that the U.S. government is going to take against an individual or an entity outside of the borders of the U.S. to effectively enforce the U.S. law. As William mentioned previously, the USPTO adopted new rules in 2019 to help promote compliance with the USPTO's rule, and that is in all trademark matters filed by foreign applicants. Those trademark applicants must be represented by a U.S. attorney. And now I'm going to turn it over to Tom to discuss Rule 11.18.
Thank you, Mike. So, what is your signature and what does it mean? And I ask that question because in U.S. courts, there is Federal Rules of Civil Procedure Rule 11. Before other agencies in the United States, you don't have as strict an obligation as before the USPTO. USPTO is special. They justify it a few ways. So, they require basically three things in terms of a signature. The first of which is that the practitioner personally sign the paper. Now you can do it by electronic signature by putting your name typed in between slash marks. Or you could do it with pen. However, you can't ask your secretary, paralegal, or someone else to sign for you. And I will get into this in a little bit more detail, but everywhere else in the world, I can, figure if it's a proceeding before a court, before a different agency, I can have someone sign for me. All right? You also have this issue that you have to have where it's a reasonable basis to believe that the person who signed actually signed. Now again, why? Here's why. This is a big one. All statements made therein of the party's own personal knowledge are true, and all statements made therein on information and belief are believed to be true. If any of you have ever signed a declaration, which is a sworn statement, that's what is required by law that a practitioner before the patent office, when they affix their signature to a document, that they are making a truth certification. They are taking an oath in essence. So, I said that the USPTO justifies this. I also had the pleasure of teaching in other aspects, and had last month a representative from the USPTO's Office of Enrollment and Discipline, like this, in the last session of the matter, giving the ethics talk. And he very firmly justified that this is an important aspect, this truth certification, as well as the personal signature, because they will hold fast to, you must personally sign that document because you're making a sworn statement. So, file application papers, and I go through it, it's a formality sort of document, I'm making a sworn statement. When we're saying that an applicant is a small entity or micro entity, if I'm signing that, I'm making a sworn statement. If I'm making arguments before the Patent and Trademark Office as to patentability, I'm making a sworn statement. And in this instance, they justify this requirement because of our Rule 56, which calls for that there would be good faith duty of candor before the office because they can't investigate everything. Now, this rule came about when I was young and in practice, and I remember back then that the USPTO had paper files. They had this horrible problem of losing their paper files. And you would get a call and be asked to reconstruct the USPTO's file that was lost. They found that examiners were actually to meet their work requirements, would put them up in the ceiling and drop them down an elevator shaft. True stories, okay? And the partner I was working with at the time got the call, I put everything together, and I put forward a declaration that this was true and correct. And it was before this rule came into effect. And the partner said, no, I'm not signing a declaration. Just give me a cover sheet letter that says that it's true. I don't have to give a sworn statement. Just shortly after that, the rule changed for the sworn statement to come into effect. And again, this is in contrast to something else. U.S. patent examiners don't have an obligation to tell the truth to the applicant, and we can discuss this, but I sometimes think that they don't tell the truth. That said, this is an important aspect of when you're practicing before the PTO to remember you're telling the truth, the whole truth, and nothing but the truth. So, with that said, there's another aspect of this. That you're making the paper, you're making your assertions after a reasonable inquiry, and that you're not presenting it for an improper purpose. And that your legal contentions are warranted, your factual or contentions or evidentiary support is also warranted. And now, consider what I said earlier about the people who are mere conduits. They violate this rule because, I have seen this, they get something that's written based upon some associate in Europe's view as to what the US law should be based upon European law. And there goes Ron X just signing away. And you know, the problem is that this clogs up the system with frivolous arguments, but it also means that there's unwarranted contentions that get frequently filed at the USPTO. So, that said, that's where the patent office is at and where the rules are at. And again, as Mike has pointed out, they kind of, you know, they have rules, but they're not necessarily have the ability to enforce those rules. So it's up to us as practitioners to just do the right thing because it's the right thing to do. So I will turn it back over to Todd.
So what do you do? The USPTO has or doesn't have the type of teeth that courts would have because they are an agency, especially if the wrongdoer is nowhere to be found in the US. What do you do? So to the extent that they could, they did try to put some teeth into making sure that the practitioners practice properly. The two types, I think, that I mentioned earlier is that there are disciplinary rules and there are sanctions. OED, the Office of Enrollment and Discipline, are the ones that monitor the proper practice and ethics that the practitioners are held to when they represent their client before the USPTO, whether that's on the trademark side or the patent side. And just to, if you're not familiar with some of the US nomenclature of some of the rules, what Tom and Bill earlier mentioned when we were talking about the micro and the small entity is that the US Patent Office, both trademark and patent side, have a fee schedule. And these fees are discounted substantially for small and micro entities where they have very little or no employees. And so there's an incentive for some of these, especially the foreign entities that are subsidized by the government with a certain amount of money to fraudulently say that they are a micro or small entity. And so these declarations are actually forms, but just like Tom said, when you sign on this form, it's almost a sworn statement, or it is a sworn statement, even though it's a form. And so in order to prevent these improper practices, the Patent Office has provided certain type of sanctions. Now, these sanctions are not like a court where you're going to be fined or there's going to be penalties, monetary or otherwise, but they are substantial consequences if you have been found to improperly practice before the office. And that includes striking the offended paper. That includes the matter being referred over to OED for disciplinary actions, precluding a patent or a practitioner from being able to present anything to the Patent Office in order to represent the client for that particular patent or for that registration of the trademark. It also affects a negative inference of what you actually did present to the Patent Office as to the effect of the weight given to the paper or the filing that was done properly. And the most I suppose the strongest sanction is terminating that particular proceeding. And what we mean by that is that the patent application or the patent or the trademark is basically canceled. They said, this particular practitioner, everything that they filed so far is we're just going to not review these anymore. And so the sanctions I mentioned earlier applies not just to the practitioner, it actually has a bigger effect on the actual applicant of that particular patent or trademark that is being represented. One example is In Re Chen Yan. This was so Mr. Yan filed a bunch of trademark applications before the Patent Office. But upon review, we don't know exactly how this came about, but there were questions as to the signatures, who actually signed these things. And so upon inquiry, the attorneys' names that appeared on the papers that were filed, turned out that the attorney said, I have no clue who this is. I didn't file it. I didn't sign it. And so Mr. Yan here was just randomly putting attorneys' names who were registered before the Patent Office onto these papers to get them filed. And because of the nature of the wrongdoing, it was also found to be willful and intentional. And so for this particular case, the consequence was sanctions. And so none of the applicant's filings were given any weight. It was considered to have been intended to mislead the Patent Office and causing, committing fraud before the Patent Office, I say Patent Office, the Patent and Trademark Office. All these applications were voided because it couldn't be cured. The filings were not to be given any weight. And so the PTO canceled these trademark proceedings, and the client, whoever that may have been, ended up with nothing because of this wrongdoing. The slightly difference between the sanctions and the discipline is that the discipline, again, goes directly to those who have been registered at the Patent Office. The Patent Office keeps a registry of all the applicants, the registered practitioners. And so when some of these are referred over for disciplinary action, what can the improper practitioner, the practitioner who did improper acts before the Patent Office, the consequence may be probation, public reprimand. Probation is more like a warning. Public reprimand is the Patent Office publishes what's called an OG, official gazette. And in those things, they will actually name you as being done something wrong. And so it's a public reprimand. The next one above is suspension for a certain period of time that you can no longer practice before the office. And the worst case is the exclusion, which is, it says right here, it's equivalent to a 5-year suspension. So another similar case of what we just saw with Mr. Ian is in Ray Zhang. And so very similar, but the difference is that this was a practitioner where a lot of these applications, and you can see the numbers here, talking about 8,000, 8,500 in 2020, almost 10,000 applications in 2021, just massive filings. And very similar to what Tom was saying was these are conduit filings. We call it robo filings, or sometimes we call it rubber stamping. They just get something from somebody and they say, oh yeah, sure, slap on your signature, stamp, and get it filed. And so these were not reviewed properly with the type of certification that Tom mentioned that this particular practitioner was doing. And so the disciplinary action for this person was that there was a 90-day license suspension and couldn't conduct any type of business before the Patent Office. And so you kind of have to think about this, and this leads into, and Mike will lead our discussion here for the panel, but there's 3 characters, cast of characters here. You have the U.S. practitioner, you have the end client, and then you have these foreign associates, or those who are practicing somewhere between, especially for foreign interests. And so what do we do, right? What's the best way of doing this? Mike's gonna lead that discussion.
Thank you, Kyle. So we have this serious problem now that the U.S. government is taking a significant interest in that they never really did before, but they have, and now it's on the table that the relationship between foreign associates and the U.S. counsel and their clients is something that is being very well scrutinized. So we need to come up with some safety measures for legitimate practitioners to help guide them and ensure that they don't become subject to one of these terrible sanctions orders that can affect their own license and it can affect the patent and trademark rights of their clients. So what are some of the things that our panelists have seen that are good measures when dealing with foreign attorneys and foreign intermediaries, foreign agents in representing foreign clients before the USPTO? What has our panelists found that to be some best practices and say safe practices to ensure that these sanctions type issues don't arise?
This one's wired, so we have to watch our line. I think, I mean, we have slides that deal with some of the details of what we're going to be talking about. But for me anyway, it's two very broad issues. Who are you dealing with? I think is the biggest issue. I think right now, so due diligence. Know who you're dealing with. As a U.S. practitioner, you got to know who your client is, and you got to know who the foreign associates are, and what's the relationship between the two. And then you have to know, what am I doing with that information? Am I robo-stamping, robo-filing, or just rubber stamping? Or is there some oversight and supervision that's going on before anything gets filed before the patent office? I think Tom actually had some good practices that his firm has been implementing to make sure that you stay away from these type of issues.
Thank you. Well, this is a tough call because you have a foreign, in the legitimate sense, you'll have a foreign associate, a patent agent who has a relationship with a client, and you don't want to be interfering with that relationship. On the other hand, you also want to make it clear that you're the practitioner before the U.S. Patent and Trademark Office, and that you're exercising professional judgment, not just simply passing things through. So there are two aspects of this that I think in our slides we go through. The one of which is that you can't be the conduit, but also there are, again, two sides to this. The first of which is, I'm in the US and I'm sending out patent applications on behalf of my client. So what am I looking for in that instance? I'm looking for someone who is going to do the work competently, who's going to be me in whether it's Korea, China, Japan, the European Patent Office, etc. Someone who I know knows how to do the job. And somebody who knows that they're getting the work based upon that I've done actual research on them, that I've made sure that they're qualified and that they have enough people and basically bench strength to do the work, and that they have a good track record. Someone who says to me, I've got 100 agents in the back room, and I go, okay, but do they know what they're doing? And that they also handle conflicts correctly. I was interviewing firms in China several years back, and I made the point and said, well, you know, our client's technology is this, do you handle anything like that? And one firm said to me, well, if we do, we just make sure someone else works on your work and that person works on the other client's work. I thought, well, gee, that really isn't very comforting. So, I mean, those were some of the aspects of this, and that then you have to be substantively involved with the relationships. When you get an application in, and I appreciate sometimes you get it last minute, same day, gotta get filed. But most times you make the point to the foreign associate who's sending you work and the ultimate client that we'd like the work to come timely so that we can review it, so that we get the draft of the application, go through it timely at a filing, make comments on it, perhaps review it with revisions that the client will actually see that we're substantively involved in the work that's being done. That is a very important aspect, and making sure that when it comes to, for example, whether you're a small entity or a micro entity, in other words, what's the size of your business and how much money you have, that the client is signing off on something like that, not me, because I don't know all of those details at any given time. And then the other aspect I will say is, I get daily emails which have a caption in the subject line, must read, must sign, which I know that seems like a pain in the derriere. However, it means that I log on and make sure I type my signature in and make sure that it's all there. I also make sure that, if somebody says to me, I want a reciprocal relationship with you, I want to expect that I will receive X number of cases, I shut down that conversation and say, I'm sorry, that's not me, that's not Dwayne Morris. And then the other aspect that I think that Kyle alluded to is, we have as one of our slides, the example of our Shanghai office. Our Shanghai office has practitioners who are licensed to practice before the patent office in China. They have clients who are in China. And what they do is they will prepare patent applications. They will prepare draft amendments. But what happens is those documents come to me or one of my colleagues, depending upon the technology, and we thoroughly review them. And we will make changes. It will go back to the client in Shanghai, and then come back for us to actually sign it, so that there is never an instance where they're just simply writing something, putting a name on it, and it gets filed with the patent office. And then the other aspect of it is that we also ensure, in working with both our office in Shanghai and foreign associates, that the foreign associates are not giving opinions to the clients on the validity and infringement of a U.S. patent. And in fact, I can tell you, about a decade ago, I was lecturing on this in Munich, and made the point that if you're a European patent attorney and you're writing opinions on whether a U.S. patent is valid or a U.S. patent is being infringed, that is subject to discovery in the U.S. It is not privileged. No court will let you shield that opinion. And you can't rely upon it for defending against treble damages. I can tell you there was an uproar in the room. There was a representative of the USPTO, there was a representative from the PTO, and these people started yelling at me saying, you must change this. We do this regularly. And the people from the EPO said, you're registered at the European Patent Office, why are you opining on US patents? The US Patent Office representative said, we agree with what Tom said, you're not allowed to practice that way. And so, in the sense of it all, we make sure that we give that advice thoroughly. And then the one thing is a big caution when you're dealing with a foreign associate. If the foreign associate sends you a document, here's a brand new patent application, and by the way, here's a letter that says that you're signing off that we, firm X, say, in the UK is your client, send it back, because they're not the client, and you will get in trouble for signing that letter. So, those are some of the aspects of what we look for to make sure that we're clear that the foreign associate is not the client is the real client. And what we do is we send a retainer letter. And we tell the foreign associate, if you're signing on behalf of the client, you're making an affirmative representation that you are authorized to do this, and that the client knows we are being retained on the client's behalf for the patent matters. So that it's clear that in the retainer letter, we're always stating the ultimate applicant, assignee, applicant is the one who is the client, not the foreign associate.
So Tom, let me ask you this too. When you're dealing with, so one of my experiences working at a large IP firm for many years, and most of our clients were not from the United States, was that the founders of our firm and many of the older practicing attorneys affirmatively refused to enter into written engagement agreements with foreign associates or with their clients. Everything was a handshake deal with the foreign associates, and there was no deal at all with the clients, because they found, even against my advice as the risk management attorney for the firm, that they thought it was rude, or that it would be considered improper, and that they felt badly about asking those people to sign something. So just as a matter of policy, they would refuse to get anything in writing. Have you come across that, and how do you deal with it?
You know, it's funny because when I first started in practice and we were talking about this, that, and I am looking for someone to tell me I don't look as old as I am, okay? I am like fishing for a compliment here, okay? That was in the 80s and 90s, the mindset. And then by about, say, the late 90s, early 2000s, it suddenly became that New York State and the other states would, when a practitioner didn't get paid and sued for the money, they'd say, where's the retainer letter? You don't get paid without a retainer letter or without even trying to send a retainer letter. And I was at a firm at that point where the managing partner said, sophisticated clients expect a retainer letter, expect to know how much you're billing, who's working on the matter, how disputes are going to be resolved, how the relationship terminates. And if you don't do it, we're going to never be able to collect the money if someone stiffs us. So now I'm at a annual, I guess 100 or maybe less firm. I mean, it's about 900 attorneys globally. And we have a very strict compliance counsel, general counsel, and you can't get a matter done if you don't get the retainer letter back signed. So as to make sure that we are following the various state rules and making sure that it is being done properly. To the extent a foreign associate may say, well, my client may be insulted with that, I end up just simply saying, I'm required by law to get that signature that I'm representing that client, and I cannot do your work if I don't get that as a matter of firm policy.
Right. It's like it's like going to a bank and asking to take out a loan, but you don't want to fill out any loan application or sign any documents. You just want the money, and you promise to pay back.
I think there's a guy on trial in New York about that.
We won't name names.
Those are really good advices. But if I could add one more thing is that for example, working with foreign associates, essentially you're filing United States patent applications, for example, on behalf of former corporate clients, such as Samsung or SP90 and so forth. And they've been in this business for a long time as well. I've been filing patent applications in the United States for about 23 years. And if I compare 23 years ago and now, the quality of the patent professionals here in Korea, for example, is I say pretty high. It's very high. And we get the patent application, the hundreds of applications coming to our law firm, and our lawyers work on those application papers, and we have the paralegals that are quite versed in those paper matters. So in the end, you get comfortable. You think that everything's going to be going well because you've been doing this for day in and day out for so many years. Well, I'd like to add one thing here is that as an attorney, you're responsible for it. You must get all those documents, and when your name is signed, you should know what you're signing. So that would be the one takeaway that I like to keep up.
Yeah, I mean, that's really important. I think both what Bill and Tom has suggested is from the U.S. attorneys and the U.S. Practitioners' perspective. I don't know if any of you are in-house attorneys here, but you also have to think from the company's perspective or the client's perspective. Who's working on my application? Who is working, filing this thing at the patent office? And of course, like Bill mentioned, I used to be in-house also, and so I kind of had to monitor this as well. But as in-house, you have to know who it is at the end that's corresponding with the patent office, patent and trademark office. You have to know where that the paperwork went from, because a lot of times, especially with both trademarks and patents for registration, as you know, requires a lot of input from the client because it is their technology, it is their brand that has to be filed to the patent office. And so when this paper and information flows to the end practitioner, and as I mentioned here, from the sanctions perspective, the person that's going to be hurt the most is me as the client if my U.S. practitioner isn't doing their work properly. And so you have to vet and make sure, especially if it's going through a foreign associate, if what I'm sending, is it going to the U.S. practitioner properly? Is there something else going on in between? And so there, of course, has to be some trust between me and, if I'm in Korea, our Korean counsel and Korean colleagues who are preparing and sending stuff over to our U.S. colleagues to make sure, as Bill mentioned, not to get too complacent, make sure that what's being filed at the other end is being done properly, otherwise it's going to be on me.
One thing I think I would like to add is that at the beginning, Mike gave us all some really nice introductions. One introduction we didn't do was of Mike. Mike, your practice is protecting lawyers, especially in the space of practice before the USPTO. You handle the practice of protecting or defending attorneys who are charged as to matters before the OED, or Office of Enrollment and Discipline, as to ethics. And I raise that up because I think you've seen the signature issue rear its ugly head when, for instance, disgruntled employees. And if I may turn the tables a minute and ask, can you give a little discussion on that?
Sure, yeah, and that's really why I proposed this topic for this conference, because in the last several years, my practice has changed from representing patent and trademark lawyers in all kinds of matters to representing patent and trademark lawyers specifically because of the work they're doing or not doing on behalf of foreign clients, and particularly with people who are filing large volumes of either patent applications or trademark applications. The main themes that I've seen that the Patent Office have developed, what I hear from the U.S. Patent Office officials who are concerned about all of these issues that arise, is that the U.S. attorney has an obligation to do work. They want to see that the U.S. attorney isn't just being a rubber stamp, and that they are doing a reasonable pre-filing investigation. Now, what's a reasonable pre-filing investigation? Well, it depends on what the circumstances are. If you're going to file a patent infringement lawsuit, patent infringement lawsuits cost millions of dollars, they take years of time. There's a very high level of due diligence that attorneys should do before filing a lawsuit for patent infringement, because of the expense involved and because this is a huge effort involved. But on the other hand, when people file trademark applications, and I've seen this initially occurred a lot in trademark applications, where people view patent litigation on one end of the spectrum, or trademark litigation on one end of the spectrum, but on the other end of the spectrum they say, trademark application, well, it's very simple. It's a form, there's 6 or 7 questions, you check a couple of boxes, it seems very easy, and so it seems like it's a very short amount of time for doing anything. And what I've seen occur, and this is not an issue, by the way, that I've seen occur in Korea, with any Korean foreign associates at all. The issues that I've seen are coming out of China, and they're coming out of India. And the two common denominators I see in those countries are that the people that are in the business, on the business side in China and in Korea, who are the ones who are directly interfacing with the clients, they are extremely cost sensitive. I mean, way more cost sensitive than anyone else I've ever seen before, to the point where they're delivering trademark applications. They're promising to deliver for their clients trademark applications to be filed in the USPTO for less than $25. I've seen people, I've represented some of them who have done trademark applications for $5. What are you going to get for $5? I can't even buy a cup of coffee for $5. And these people are, and so this is the cost sensitivities that they're working with. That means that this motivates the U.S. attorney to do no work at all. That the most they're going to do in a case, if they do it at all, is to just sign the document. And in many cases that I've seen, they don't even sign the document themselves. They allow the foreign associate to sign their name to the document, in which case they're completely cut out of the picture. They haven't seen the application, they haven't reviewed the application, they haven't done any due diligence to verify if it's well-founded, if there's a good faith, reasonable basis for believing what is stated in these applications. They're just cutting themselves out of the picture because they've been allowed themselves to be essentially allowed their independent judgment to be overtaken by somebody else from a foreign office, because that someone else is paying them what amounts to a little amount of money. $5 a trademark application, $10 a trademark application. I've seen some people that do it on a fixed monthly rate, let's say $1,000 a month, that the U.S. attorney will get for their services. But those are really big red flags. If you're going to get some fixed set amount for what could be hundreds of cases, that's a big red flag for the USPTO officials who I interface with, that say, there's a problem here. When somebody files 300 applications for trademarks in a single day, a solo practitioner, by the way, not a big law firm, but one individual, I can't fathom how that would be working 24 hours a day, and you'd have to sign at least 15 applications an hour, every hour, for 24 hours a day to meet those kinds of volume numbers. It's just not realistic to spend, that's 4 minutes. That's no breaks also. No lunch, no dinner, no breakfast, no sleeping, okay? Every 4 minutes you're a robot. You're just sign. It's just enough time to open the document, enter in your signature, and close it and file it. That's a limited amount of time. Maybe you could do that in 5 minutes, but you're literally doing no work. So the clients who are getting in trouble, people who are getting in trouble are those who have allowed themselves to have essentially loaned out their law license and aren't doing any independent work. And what the number one thing I hear from the USPTO's disciplinary officials is that they want to see the U.S. attorneys doing the work. They have a duty to exercise independent legal judgment, and that means that they have to actually review the materials. They have to question those. Is this accurate? Do they know that the clients know, for example, for a trademark application, that there's a requirement of use in commerce in the United States? And are they making actually use in commerce in the United States? Use of commerce in the United States is a very complicated subject. There are volumes of books written on that subject. And just checking a box to say, yes, I'm using it in commerce, is a complete abrogation of your responsibility as an attorney. And they're essentially giving up their law license for a little bit of money. And so, I don't see that in a big scale of people doing that, but I see it. I see more and more people that are continuing to be incentivized to mass file for a little amount of money, to spend no time thinking that it's okay to allow the foreign associate or the foreign agent to do the work. And I go back to the 1980s guidance that the USPTO gave. Where the USPTO said in the 1980s, it's okay, you attorney, that you can rely on instructions from the foreign associate, but in 2023, they're not saying that anymore. What they're really saying is, yeah, we're not separating ourselves out from the 1980s opinion. It's just that we have more stringent standards in 2023. And this, now we expect our U.S. attorneys to actually ask questions, to actually do work. And the clients that I typically am representing in this space are getting caught in that area where they can't show that they've done the work, because in fact, they didn't really do the work. They just allowed someone else to do it. They were truly a conduit, including to the point of even the most extreme conduit is not doing any of the work, allowing your name to be signed on the document, and allowing it to be filed under your name with all of these representations under Rule 11.18 that you've certified, etc., all of those things. And that's just a horrible precedent. And the USPTO is going to continue to sanction attorneys. They're going to continue to sanction patent applicants and trademark applicants until either they all get sanctioned or the people start getting it right. At some point, maybe they'll run out of people to sanction, but they're increasing their sanctions, they're not decreasing them. So it still continues, and I hope we get the message out that to the world that this is a new order that really needs to be people need to be mindful of. And it's at 6 o'clock. Anyone have any questions?
One quick question. So I think Tom mentioned that you're really against reciprocity. What's wrong with that? Because that's a very common practice.
It's unlawful.
It's unlawful?
It's unlawful. Let's go there.
You go to these...
Here, let me explain.
Yes.
All right? My client pays me to do the best job to find the best attorney, say, in Korea. If I'm getting my hourly rate for doing my job, but I'm also making a side deal with you that I'm getting the case back, I'm now getting additional compensation that's not being reported to the client. So it is an unlawful act.
Okay.
So
it's so common.
It may be common, but it's wrong. And I don't do it because it's wrong.
Okay.
All right? I'll be glad to take work in from someone who will demonstrate to me that they also do great work, and I will send work to someone who does great work. But I will not base my practice on the expectation that I'm to send you a case. I'll tell you a story. All right? I have a client in Europe that I've been working with for many, many years. All right? The client selected me. And they also do work through a foreign associate. Actually, a number of different foreign associates, but one in particular. And the foreign associate came to me at a conference and said, "We're expecting you're sending back the same number of cases that you're getting sent because the client directs us to send it to you." And I said, "No, I'm not going to send you a damn thing now." And they said, "Well, we'll go tell the client." I said, "Actually, I'm telling the client that you threatened me and that you're expecting that you're to get additional compensation from me via cases of other clients for their work." And I did go to the client, and I did report it. The client still works with me today. Do you think they still work with that foreign associate? No. All right? So yes, reciprocity is wrong unless you fully disclose to the client that you are receiving side compensation from the foreign associate and that you're sending the client's case on the basis of this reciprocity, not so much on the basis of I'm selecting the best attorney for your case.
Well, a lot of times the relationship is such that there is a trust of the quality of the work before you talk about it.
You have to establish that relationship. But I have a lot of overtures from people who start with, "I want reciprocity." And I shut that down and say, "No, I'll work with somebody on the basis of trust. on the basis of demonstrated quality, demonstrated ability to have the bench strength to do the work, demonstrated ability in terms of the technical competence. I mean, I've seen firms where they want to put a mechanical engineer on a biotech case. Please. I can't countenance that. I have an obligation to the client to make sure that the right person is doing the work, not a mechanical engineer handling a genetic engineering case. So I'm sorry if I seem very vitriolic about this, but it is one point where I am very adamant because I do feel it is so wrong, it is so improper to the client. I have lots of friends who are patent agents, attorneys in various jurisdictions throughout the world. When the case is right for their firm and their people, I will do it. The flip side, I'll tell you. I had a number of patent prosecutions as well as a matter of both litigation and an interference. And the foreign associate shows up when I'm there to start looking to do discovery from the client with their brand new hire who happens to know the technology, and we handle contentious matters globally. And this person will do the discovery for the client for much less than your firm. And I looked at the client and said, I cannot give my professional judgment to somebody who's not a U.S. attorney working directly under me in my firm. And that is part of the reciprocity problem, is you're abrogating the responsibility when the relationship is based upon you give me 5 cases, I give you 5 cases. Because I've seen where, for example, in a firm I was at several years ago, biotech matters being handled by a mechanical engineer who was just signing off on it. And it was wrong in so many levels, including the claims were just totally off and not appropriate. So, no, I am not a fan, and I believe it is wrong, and I will, to the day I stop breathing, lecture against it.
I see.
We're going to close. Thank you all very much for coming.